quick note then, in case anyone else was unable to hear me, just a big welcome to everyone who joined the session today. If you do have any questions or technical issues during today's session, you can let us know in that questions tool at the side of your screen, and a member will be on hand to support you. Today's session is being recorded, and we will be sharing a copy via email in the coming days. But yes, over to David to get us started.
Thank you, Jordan. And Ann Tyler, if you don't mind just reversing the slides to the title slide for me, that would be helpful. And we'd like to welcome our audience today. Good afternoon or good morning, as the case may be for some of you, and good evening for those of you in different geographies. We are so excited that you've chosen to join us today for Navigating COVID-19. We'll be talking about employment law and ERISA legal compliance relative to legislation that has been ongoing in the recent past, and so we're excited to share this presentation with you. We were originally slated to present with Ann Tyler Hall and Jennifer Harris, one of our employment attorneys, and Jennifer let us know late yesterday that she has a severe case of strep, and so unfortunately Jennifer will not be joining us, but you have an added bonus. You have a couple of added bonuses due to this unforeseen change in circumstance. The first of which is that Ann Tyler Hall will be with you for longer and go into a bit more depth on her topics relative to ERISA. And then the second bonus opportunity for you is that Jennifer will be recording her session separately, and we will provide everyone who registered with that additional content as soon as it is available, and we think that should be available likely early next week. So we appreciate your patience. We hope you'll stick around for the whole presentation. We will be giving an opportunity for questions at the end. Ann Tyler, if you'll advance the slide, please. If you're not comfortable submitting your, I'm sorry, let me introduce our speaker first. Ann Tyler Hall is our founding attorney. She has written a book, ERISA Case Studies, why it matters and how it benefits you. If you'd like a copy of that book, you can download a copy of that book on our website. And if you'd like a physical copy, if you're a service provider or a plan sponsor and you think that would be helpful for you and your business, just let us know and we'll put one in the mail for you. Our focus here at Hall Benefits Law is on proactive relationship-driven employee benefits legal compliance. And in 2020, we expanded our firm to include an employment law practice. So we're eager to help you in as many ways as we can, and those two practice areas are complementary. So we found that our clients are using both sides of the firm, and it's exciting because our aim is to address all areas of risk for your business. The HBL team of attorneys serves clients in 32 states, and we continue to grow. And we're most excited about the 71 million plus in penalty abatements that we have been able to do for plan providers over the last approximately 2.5 years. And so since January 1st, 2018. So we continue to work on behalf of plan sponsors to make sure that their benefit plans are compliant, and when there is a hint of non-compliance, to make sure we proactively address those issues. Ann Tyler, again, is our founding attorney and principal, and I think you'll enjoy hearing from her today. Next slide. When we send you the remainder of the presentation, you'll be hearing from Jennifer Harris. She is a fantastic employment attorney, and I know that she looks forward to recording her portion of that, and we'll get that to you again as soon as possible. Ann Tyler, next slide, please. If you would like to submit a question and you're not comfortable doing so through the GoToWebinar portal or live on the presentation today, we are more than happy to take questions. You can send those to admin@hallbenefitslaw.com. And finally, before I hand things over to Ann Tyler, I would encourage you also to sign up on our website for monthly HR alerts, details about upcoming speaking engagements, of which we do many, and then to also read the plethora of articles that our team has written over the last couple of years. We really leaned into content during the pandemic, and we have found that plan sponsors and service providers alike have really enjoyed that fact. Finally, there are 2 handouts in your GoToWebinar portal. One is really geared towards service providers. It talks about why HBL is a great referral partner for your clients if they need help. And the other talks a little bit more generally about our ERISA services. So if you have any questions about those handouts, you're welcome to submit those. Please download them directly from the GoToWebinar portal. And with that, I'm going to hand this over to Ann Tyler.
Thanks so much, David. Excited to be here today. A lot to talk about with respect to legislation passed just in the past year and a half. And we could go back 2.5 years. In the past 2 decades alone, I don't think that there's been this much legislation impacting benefits in one consolidated period, approximately 2-year period, that we've seen over the past couple of years. Some of that due to COVID, but even predating COVID. At the end of 2019, we saw the passage of the Secure Act. Now the Secure Act 1.0. There is another proposed Secure Act 2.0, percolating in Congress right now. But even before COVID, Secure Act passed at the end of 2019, had a myriad of changes for retirement plans. We don't have time to go into that today. So we're going to focus on the Consolidated Appropriations Act passed at the end of 2020, and then the American Rescue Plan Act, or ARPA, passed in early 2021. I am going to turn off my camera so we can focus on the slides. And I'll be back on camera at the end to answer questions. If you have questions as we're moving through the slides, feel free to include those in the chat box, and we'll try to get to those at the end of the presentation. So the Consolidated Appropriations Act and ARPA, we'll dive right into the changes under those 2 laws to ERISA, to benefit plans. Okay, so starting with the Consolidated Appropriations Act of 2021, this was signed into law on December 27th of last year, 2020, and it includes a litany of provisions affecting health and welfare benefits and retirement plans. The first change that we're going to talk about is the health FSA relief. And this also generally applies to dependent care FSAs, allowing for carryovers of any unused health FSA amounts, and also for an extended grace period for health FSAs and dependent care FSAs. Then we're going to talk about an optional limited extension of the emergency paid sick leave under the FMLA. And then we're going to work through the retirement plan, partial plan termination relief. And then we're going to talk through the prohibition on surprise billing, welcome relief for group health plans and plan participants. We're also going to discuss broker compensation transparency rules included in the Act. And then finally, the mental health parity transparency and disclosure requirements. Next slide. So the first change we'll dive into is the change to flexible spending accounts, both health and dependent care flexible spending accounts. So the Act provides that FSAs may permit participants to carry over their entire unused FSA balance from a plan year ending in 2020 to 2021 and or a plan year ending in 2021 to a plan year ending in 2022. So if you are a participant in a health FSA, you contributed, for instance, the maximum amount of $2,750, and you had some amount left over at the end of 2020, you can carry over that entire amount to 2021 and 2022 if the employer adopts this provision. This is optional, and the employer must adopt this change, amend the health FSA to provide for this relief. Now, previously, a health FSA could provide for a $550 carryover limit. And now the expanded rules provide for the carryover of the entire unused balance. And this is also permissible for dependent care FSAs. Alternative to the carryover amount, both dependent care and health FSAs that do not permit the unlimited carryover may also or may allow for a grace period of up to 12 months versus the previous 2.5-month grace period for plans for health FSAs that permitted grace periods. And so this is allowed for the plan years 2020 and 2021. So some welcome relief for health FSAs, dependent care FSAs, if you have a balance in 2020, 2021. If your employer adopts these relief provisions, then you can carry over the entire amount, the entire unused balance in 2020 and 2021. The next change that we'll talk about is, again, more relief for FSAs, health and dependent care FSAs, but the Act allowed for a spin down feature for former employees. So if you were a health FSA participant with your employer, you terminate employment in 2021, last year or this year, you are now, for 2020 or 2021, you are permitted to spin down your unused balance, even if you don't elect COBRA. So previously, you could spin down your unused health FSA balance if you elected COBRA through that employer plan. The Act allows that you can spin that down your unused health FSA balance or your health FSA balance through the end of 2020 or 21, even if you don't elect COBRA coverage. So some welcome relief for employees who terminated employment in 2020, 2021, if so provided for. The next change relates to the dependent care FSA age limit. So in 2020, just as a reminder, the dependent care FSA limit was $5,000. Most consider that $5,000 limit to be relatively low, but if you were a parent who had a child in a daycare or with a nanny in 2020 and for COVID reasons no longer used those services and had a balance at the end of 2020, or if you had a child who turned age 13 during the 2020 plan year, prior to the Act's relief, once that child turned age 13, they would no longer be eligible, or you would no longer be eligible to pay for their expenses, childcare expenses, after their 13th birthday. And so the Act expands the age limit to allow for parents to use unused dependent care FSA account balances for the 2020 and 2021 year after the 13th birthday of a child, of a qualifying child. So in 2020, if your child turned 13 and you still had, for instance, $2,500 left in your dependent care flexible spending account, you can continue to use that balance for that child through age 14. And I've given an example, provided for an example here at the bottom of this slide. I would note that this increase in age limit applies only to prior balances. It does not allow for prospective elections for a child who is already age 13. The next provision in the Act relates to an optional extension of the emergency paid sick leave or emergency family medical leave, or both from January 1, 2021 through March 31 of this year. So a couple of notes about this extension of the paid sick leave and or emergency family medical leave. This is not required. This is optional for an employer to adopt if they want to so provide for an extension of the EPSL or the emergency paid emergency family medical leave. That is optional. Another point, important point, is the rules that were in effect beginning April 1 of last year to December 31. Those remain substantially in effect. And so to make the point, this extension does not grant additional emergency paid sick leave or emergency family medical leave. It just extends the time during which a COVID-affected individual may avail themselves of this emergency sick leave or emergency family medical leave. And again, this is optional for the employer. The employer is not required to allow for this extension of the emergency sick leave or emergency family medical leave period. Employers may continue to claim tax credits for this paid leave taken by eligible employees during this extended period, and everything else generally remains in effect as it was when this first came out in April or became effective in April of 2020. So most of the rule remains intact, just an extended time period in which an individual may avail themselves of this relief. And this is, again, optional for the employer. The next provision in the Act, the Consolidated Appropriations Act, the next change relates to partial plan termination relief for retirement plans. And so under the existing retirement plan guidance, there is a rebuttable presumption if the number of participants in your plan decreases within a prescribed time period, generally during the plan year, during one plan year, but it could be shorter. If the number of participants decreases by 20% or more, there's a rebuttable presumption that a partial plan termination has occurred. And a partial plan termination implicates vesting, matching requirements, so it can be an expensive event for a plan sponsor if they are determined or deemed to have had a partial plan termination. And so the Act provides some welcome relief here. We had several plan sponsors in the restaurant industry, the healthcare industry, or hospitality industry who had to lay off a significant portion of their workforce for a period of time during 2020 due to COVID. And this relief provides that a plan will not be treated as having a partial plan termination during this relief period, which is defined as March 13th, 2020. It ended March 31st of this year, but that is the relief period. So if you are an employer, you laid off 30% of your workforce and had a reduction of 25% of your eligible plan 401k plan participants during that time, there is some welcome relief here from Congress under the Act. Now the rules provide for if during this relief period you hire back a certain number of participants to your plan such that there has been no more than by the end of the relief period, a 20% reduction in plan participants in your, for instance, 401k plan. So if you rehire or hire participants back to the plan that are eligible to participate in the plan by the end of the relief period, that you are exempt or you are presumed not to have had a partial plan termination. Now, the plan participants who count towards the 80% requirement don't have to be the original terminated employee. So you don't have to necessarily rehire your former employees or your former plan participants to satisfy this threshold. Now, just a note that this partial plan termination relief does not appear to be available if you rehire or hire individuals who aren't eligible to participate in the retirement plan. So either they're part-time or there's, for instance, a 90-day waiting period. They're hired at the beginning of 2021. There's a 90-day waiting period. They're not eligible to participate in the plan before the end of the relief period. We wrote an extensive article on the Consolidated Appropriation Act, partial plan termination relief. Please check that out for additional gloss. We provided some examples. But some welcome relief for plan sponsors who may have had to do mass layoffs at some point during 2020, but have since rehired to the point that they have at least 80% of the number of plan participants that they had prior to the mass layoffs. Some welcome relief for group health plans and plan participants. The Act includes a prohibition on surprise billing. Now, this becomes effective prospectively starting January 1, 2022. And we're expecting further gloss and guidance with respect to this change. But what we do know is that patients cannot be balance billed for out-of-network emergency services. Specifically, this protection applies from the initial evaluation until stabilization, when the patient can consent to a transfer to an in-network facility. So no surprise billing for these out-of-network emergency services. This protection applies to both out-of-network facilities and out-of-network providers. It also applies to air ambulance services, but not to ground ambulance services. And so the idea is that a group health plan and thereby a participant cannot receive a surprise bill for out-of-network emergency services, that there has to be a notice or a requirement around out-of-network emergency services and balance billing. So plans that offer coverage for emergency services must provide such services without prior authorization requirements, regardless of whether the provider is a participating provider or a participating emergency facility under these new requirements. Patients can only be balance billed for non-emergency services performed by in-network facility by an out-of-network provider under certain circumstances. And this is intended to protect patients who receive care at an in-network facility from surprise billing by an ancillary provider. So even in-network, you're in a in-network facility, if they have an out-of-network provider, you can only be charged or balance billed provided for certain circumstances. The prohibition on surprise billing provision in the Act does allow patients to waive these protections by consent if they're notified at least 72 hours in advance of the care. And so there are explicit requirements around this exception to the balance billing that must be adhered to. In addition to the prohibition on balance billing for out-of-network services for out-of-network providers, even in an in-network facility, that the no surprise billing provision in the Act also provides for a dispute resolution procedure that includes binding arbitration to resolve conflicts between the health plan and out-of-network providers regarding the costs and out-of-network care. There are also various cost estimate, transparency, and other disclosures, including in-network and out-of-network deductibles on insurance cards that must be provided for beginning January 1, 2022. Plans must also offer price comparison guides by telephone and on relevant internet websites so that participants may compare cost sharing amounts. And no later than January 1, 2022, plans must comply with an expanded external review process in the case of an adverse benefit determination, and with advanced cost estimate notifications and explanations of the benefit procedures. So some additional external review required as part of the no surprise billing. So litany of new requirements aimed at protecting group health plans and their participants from surprise billing, balance billing. Next, we're going to talk about broker compensation transparency rules. So health plan fiduciaries generally have a duty to understand their arrangements with insurance brokers, including both the direct and indirect compensation that the broker receives. And where a broker is paid solely in commissions from the insurance company, the services are still not truly free to the employer, given that those commissions increase generally the insurance premiums. And so the Act is looking at greater transparency with respect to broker and consultant compensation. And so the Act includes additional requirements regarding broker and consultant arrangements and compensation. Specifically, it expands ERISA Section 408(b)(2) service provider compensation disclosure rules to apply to group health plans. So previously, ERISA Section 408(b)(2) passed in the early 2010s applied to retirement plans. This has now been expanded to cover group health plans and the brokers and consultants and their both direct and indirect compensation that they receive from the health plan. The disclosure requirement applies to compensation paid to any broker or consultant that receives $1,000 or more for their services. The Act requires brokers and consultants to disclose a description of the services that they have provided and all of their covered compensation, both direct and indirect. Again, this mirrors retirement plan side disclosures required under ERISA Section 408(b)(2), but expands this now to encompass brokers and consultants for group health plans. The next provision relates to mental health parity, transparency, and disclosure requirements. This has been keeping us at HBL very busy. So this was a provision in the Act that took effect very soon after the passage of the Act, became effective in February of 2021. So this requirement and transparency rule applies to the provision of mental health parity services and care. And so the provision relates to non-qualified, non-quantitative treatment limits and confirming that those NQTLs are consistent and are in parity with general medical care treatment. And so the provision in the Act provides that if an employer does not comply with the mental health parity transparency rules and provides for a comparative analysis upon request, they're given a 45-day correction period in which to comply with these mental health parity transparency and disclosure rules. But if the plan is still found to be non-compliant, the plan must inform all participants that it does not comply with the mental health parity comparative analyses and transparency rules. And the DOL will identify non-compliant plans in its annual report to Congress. So some significant repercussions for non-compliance with the MAPIA comparative analyses, the MAPIA transparency rules. And so we're working with third-party administrators with service providers to quarterback this process for our self-insured health plans. But it is a quite extensive analysis. It's a complicated analysis. There are some subjective pieces of this analysis, but it is very important if you are an employer with a self-insured health plan that you are either in the process of working with your third-party administrator and ERISA counsel, or aware of and beginning this process of preparing and being available to provide upon request to the Department of Labor this comparative analysis report. And just to give a little bit of gloss to the definition of a non-quantitative treatment limit, this NQTL, that includes pre-authorization requirements, requirements of written treatment plans, the probability of improvement evidence. All of that must be in what is considered parity. So mental health treatment for these non-quantitative treatment limits must be in parity with the general medical treatment provided for under the plan. We've had some interesting outcomes when working with third-party administrators. Some third-party administrators are recommending a wait and see approach to being asked as an employer or as a self-insured health plan for the provision of this comparative analysis. We do not recommend a wait and see approach. We recommend that plan sponsors either commence immediately this review with their third-party administrator and ERISA counsel, or start to look for a service provider who can facilitate the provision of the MAPIA transparency requirements, aka the comparative analysis required under this new rule. And so very important for health plans. This is a new requirement, and it's also our review and analysis of this provision that a participant under provisions ERISA 104B, and a participant could also request this comparative analysis, and there are some significant penalties and repercussions for an employer's failure to provide requested and required plan documents under ERISA section 104B. So significant repercussion for failure to comply with the MAPIA transparency rules and the comparative analysis requirement. Plan sponsors should be working with service providers, working with third-party administrators and their ERISA counsel to be ready to provide this this documentation upon request. There's also some FAQs that were released on April 2nd. I included a link to those that may be helpful for getting a little bit more gloss into the requirements related to the MAPIA transparency and disclosure rules. Finally, we're going to just mention briefly some other changes under the Act. Those include welcome repayment relief for student loans, and the Act enables an employer to contribute up to $5,250 toward student loan repayment, and this is tax-free to the employee. This relief is available beginning January 1, 2021, and it sunsets at the end of 2025. So for a 5-year period, employers can provide up to $5,250 towards the repayment of an employee's student loan, and that is tax-free to the employee. There are specific guidance and guidelines around what those monies can be used for, and it includes tuition expenses, books, supplies, but the rules provide for explicit guidance on what this student loan repayment tax-free benefit to the employee can be used to cover. Also wanted to finally mention some special disaster relief that was included in the Act. This pertains to qualified plan distributions, qualified retirement plan distributions, and loans taken by participants who may have had a principal residence during a qualified disaster period, during a qualified or living in a qualified disaster area, who suffered economic loss due to the qualified disaster. They can avail themselves of some early withdrawal penalty relief. They can also are permitted to recontribute hardship withdrawals that they took for home purchases. And this special disaster relief also provides for a temporary increase in plan loan limits. So some welcome relief for individuals, for plan participants, retirement plan participants who may have been in a qualified disaster area during an incident period and needed to take out monies from their retirement plan. So that covers the ERISA provisions, some of the ERISA provisions, benefits provisions included in the Consolidated Appropriations Act. We will now turn to ARPA, American Rescue Plan Act of 2021. This was signed into law on March 11th, 2021, so about 2.5 months after the change in administration, changes in Congress. We then saw, after the passage of the Consolidated Appropriations Act, we then saw the ARPA signed into law in March 2021. So the most significant, I think, provision, certainly in the short term, related to a 6-month 100% COBRA premium subsidy for certain former employees. And we'll talk about that in more detail. The ARPA also increased dependent care FSA exclusion limits for 2021, provided some relief for both single and multi-employer pension plans, expanded the definition of covered employee, and provided for a voluntary extension of the FTCRA through September 30th, 2021, and Jennifer will cover that in more detail during her presentation. Jumping right into the COBRA subsidy. So ARPA created a 100% COBRA premium subsidy for any period of coverage during the period beginning April 1, 2021 through September 30th, 2021. The premium subsidy, which also covers administrative fees, is available for any employee or dependent who loses group health plan coverage due to an involuntary termination of employment or because of a reduction in hours, and elects COBRA coverage. And so employers are responsible for paying the premium, and they'll recoup the expenditures through credits on their quarterly payroll tax returns. So this will be claimed in most cases on the quarterly Form 941 employment tax return. If the subsidy that the employer pays is higher than payroll taxes, then they can apply for and receive a refund. The credit amount is equal to the amount paid by the assistance eligible individual. That's the definition for those who are eligible for this COBRA premium subsidy, and it's based upon the COBRA premium charged by the same plan option for similarly situated individuals. The COBRA subsidy special election rules, we should note, are not optional. They apply to all employer-sponsored group health plans. And on April 7th, the Department of Labor issued FAQs. We had a lot of questions from our plan sponsor clients about the provision of COBRA the COBRA subsidy and the provision of COBRA benefits immediately, and who is responsible for determining, for instance, whether someone has experienced an involuntary termination. The Department of Labor and the IRS both issued FAQs, the DOL on April 7th, and on May 18th, the IRS issued FAQs. IRS provided some additional gloss on involuntary termination, but we've had a lot of questions from plan sponsor clients about what is an involuntary termination. Can there be a constructive discharge? Is that an involuntary termination? What about termination for good reason? So if you are an employer and subject to these COBRA subsidy requirements, you need to be tracking your terminations and whether they are involuntary or voluntary. And also this applies to individuals who previously had terminated employment. So there is a look back period for this COBRA subsidy that provides for the COBRA subsidy for those who terminated coverage as early as November 2019. So it's incredibly important that you as an employer are keeping track of those who are terminating over the next 6-month period and whether they're involuntarily terminated, and supporting documentation or supporting facts and circumstances around classification of voluntary or involuntary termination. And then there's also this look back period that we're going to jump into that applies, that requires that an employer go back then to the back as far as 18 months to November 1st, 2019 to confirm whether there may be any individuals who previously were involuntarily terminated and eligible for COBRA. Would note that ARPA does not extend the COBRA coverage period. So whatever the COBRA coverage period was at the date of termination, that COBRA coverage period is not extended. For most terminations, for most COBRA events, it's 18 months, it may be 29 months or up to 36 months in special circumstances, but generally it's an 18-month period. That period is not extended by COBRA. The ARPA are not extended by ARPA. ARPA simply provides for premium subsidy for certain assistance eligible individuals. So jumping into the look back period, ARPA also provides for an 18-month look back to November 1st, 2019, and creates a special election period for any individual who either didn't elect COBRA continuation coverage between November 1, 2019 and April 1, 2021, but who would have been an eligible individual if such election had been made. Or they elected COBRA coverage and discontinued such coverage prior to April 1st, 2021, because, for example, they couldn't make the monthly premium payment. So some significant requirements for employers to go back now and track these terminated individuals dating back to November 1, 2019 to see if there are any individuals who are eligible for this special election under the ARPA and potentially eligible for a COBRA subsidy as well. With respect to this look back period and the special election provision in the ARPA, the COBRA election may be prospective only. So in other words, the election is not retroactive to the date that coverage was lost. And once again, the actual COBRA coverage period is not extended, and it's based on the date of the original qualifying event. But individuals who fall into this, who are available for this special election period, are allowed to elect COBRA coverage within 60 days of receiving the required extended election notice from the employer. And so the notice requirements for employers, hopefully you've already, if you're an employer plan sponsor, you've already adhered to these notice requirements with respect to the look back period notice, but just also there are ongoing notice requirements. So the first notice requirement applies to any individual who becomes eligible to elect COBRA during this general COBRA subsidy period from April 1 until September 30th, 2021. So those individuals who are involuntarily terminated are eligible for a COBRA subsidy, a notice should be sent to terminated individuals, notifying them of their eligibility for a COBRA subsidy, and that will apply through September 30th of this year. So that's the first notice. Ongoing, as you have participants or employees terminated, they should be getting this COBRA notice. The next notice applies to the look back period and those individuals who are eligible for this special election. So if an individual terminated on or after November 1st, 2019, they generally should have been provided this look back notice, the special election period COBRA notice. They generally should have been provided that notice no later than last week, May 31st. There's also then a notice that must be provided to assistance eligible individuals, those impacted by these rules, notifying the individual 15 to 45 days before the COBRA subsidy expiration date, so that they have time to plan and decide whether they'll continue COBRA coverage even after the subsidy expires, if so allowed. The DOL did provide model COBRA notices for us in April. Those are helpful, but once again, a litany of notice requirements. Some of those should have already been provided. It's very important that plan sponsors are aware of either the provision of those notices in-house or that they have their COBRA administrator or service provider on top of these notices, and also ongoing, that plan sponsors are making sure that they're keeping track of voluntary and involuntary terminations. Should there be any question from participants, any scrutiny from the Department of Labor with respect to this issue. ARPA does permit a plan to provide an eligible individual the opportunity to change coverage options in conjunction with electing COBRA coverage, and the eligible individual may elect to enroll in a different group health plan within 90 days of the date of the notice of the enrollment option. The next provision that we're going to talk about in ARPA relates to temporary increases in the dependent care FSA contribution limit. So the ARPA temporarily increases the dependent care FSA limit from $5,000 to $10,500, or up to $5,250 up from $2,500 in the case of a separate return filed by a married individual. And I'm sorry, I'm having a little bit of difficulty advancing the slides. There we go. And so this is some welcome relief for the 2021 year, a nice bump in the dependent care FSA contribution limit. This is optional. Employers are not required to increase the dependent care FSA contribution limit, but the limit has been at $5,000 for marrieds filing jointly for quite some time. I think there's some hope in the industry that this significant bump was long overdue, and we may see that be a permanent change. I think that would be some welcome relief for families with dependent children. Employers may also amend their, if employers so desire to provide for this increase in the dependent care FSA limit, they must amend the plan no later than effectively the first plan year after the plan year in which this increased limit is effective. So for calendar year plan years, this would be no later than December 31st, 2022. Plan must be amended. And in the interim, of course, operate the plan consistent with the amendment. The next change we'll just talk about briefly. We've seen pension plans terminated, frozen. Certainly don't see them as common as we used to, but for those still in existence, ARPA extends some welcome relief to the funding for single employer pension plans to the funding amortization period. That's extended from 7 years to 15 years, some nice relief and expansion to the funding amortization period, and then a reduction in the shortfall amortization basis that's reduced to 0 for single employer plans for the first plan year beginning after the 2021 plan year. So this begins in 2022 for the 2022 plan year. And then also ARPA adjusts the existing interest rate corridor and implements a 5% floor on all interest rates for funding purposes. Similarly, ARPA provides for solvency relief for multi-employer pension plans, aka Taft-Hartley plans. The ARPA provides financial assistance through the Pension Benefit Guaranty Corporation, PBGC, to provide eligible multi-employer plans with the special financial assistance to better secure pension benefits for plan participants. In order to be eligible for this special financial assistance, a plan must meet one of the following 4 criteria. I won't go into that, but some welcome relief for multi-employer pension plans, aka Taft-Hartley plans. And then finally, some executive compensation changes. We generally think of Code Section 162M as more of a highly compensated executive compensation provision in the code, and ARPA expands the definition of covered employee under Section 162M. Generally, Code Section 162M limits a publicly held company's deduction to $1 million per year for compensation paid to covered employees. And prior to the passage of the ARPA, the definition of covered employee included the company's principal executive officer, principal financial officer, and the 3 highest compensated officers for the taxable year other than the principal executive officer or principal financial officer. Covered employee under the ARPA is expanded. Now, this does not take effect immediately. This provision applies generally for the 2027 tax year and later. Be interesting to see whether this change survives, depending upon whether there may be a change in administration. But at this point, beginning in 2027, the definition of a covered employee and the application of the 162M rules will be expanded to include in addition to the individuals previously outlined, it will also include the 5 additional employees that are highly compensated, the 5 highest compensated employees. So that's in addition to the existing covered employees. The rules under 162M will also apply to the 5 highest compensated employees, in addition to what's already covered in 162M, a definition of a covered employee. These 5 additional employees do not have to be officers of the publicly held corporation, of the publicly held company. And just a note that generally under the existing 162M rules, once an individual is a covered employee for a taxable year, they remain one. And for all future taxable years, those are the existing rules. But this requirement and the expansion to include these additional 5 employees, 5 highly compensated employees, that requirement that once a covered employee, always a covered employee, will not apply to these additional 5 employees as a result of the ARPA's expansion. So some significant change to Code Section 162M, expansion of the definition of covered employee, but we've got some time. That provision, that change applies for the 2027 tax year and later. So a lot to cover. We're running up against the end of the hour, but let's see if we have some questions to take.
Okay, we do have questions, Ann Tyler. If you'd like to go on camera, I'll shoot you one over here. Have a couple questions from Christine, Michelle, Ray. I'm going to start with you, Christine. You submitted a couple of different questions, one of which I believe may be a bit more employment law centric. So I'm going to go to your second. Ann Tyler, is it also your read of the expanded ERISA requirements to report income, so the income reporting requirements, that it only applies to brokers and consultants and not to other plan service providers? For example, TPAs, eligibility software vendors, utilization management, PBMs, et cetera, et cetera. So the question is, do the rules apply to all service providers, or does it only apply to brokers and to consultants?
Generally brokers and consultants, but it's interesting, the rules actually, the way that it mentions brokers and consultants and alludes to that specifically, and I think that was the intent. But if you look at the rules, they also talk about any service provider functioning or providing certain services to the plan. So presumably then one would think that potentially another service provider outside of a broker or consultant could be looped into that that definition or looped into the expanded 408B2. And I was looking, we had a summary we provided for our clients on the various ARPA, Consolidated Appropriations Act, and the CARES Act provisions, a compliance checklist, a compliance calendar. Please let me know if you're interested. But so if you look at the rules, I'm looking at this, the definition of brokerage services, right? So the expanded 408B2 rules apply to record keeping services, medical management vendors, benefits administration, stop loss, pharmacy benefit management services. Now, again, this is in the context of being brokerage services. So specifically, the Act enumerates what they consider brokerage services, but you could also imagine that other service providers would be providing these services. So this may be a bit of a wait and see to get some additional guidance from the Department of Labor, the IRS, around what is the definition of a broker, and is it could it encompass other service providers? I think it's a great question. You know, I was looking through this list at one point, thinking, would this potentially loop in, consultants even outside of TPAs, attorneys or anyone who provides these types of services. Now, again, in the Act, it appears to define these services in the context of brokerage services, assuming that these are the types of services that a broker would provide. But it isn't completely clear to me that a TPA or some other service provider couldn't be looped into that expanded coverage under ERISA 408B2.
Okay, great. Moving on to the next question. Thoughts on fully insured plans and the MPIA NQTL analysis?
Yeah, so I think on the fully insured plans, certainly the MPIA analysis is important. We expect there to be more involvement from the insurer, from the service providers for fully insured plans, but I think no less important for plan sponsors with fully insured plans to make sure that they are provided and that they have readily available MPIA comparative analyses and the disclosure requirements thereby required under the new Consolidated Appropriations Act rules related to MPIA transparency and disclosure. So I think our involvement has been on the self-insured side because there's just generally more employer involvement, employer responsibility on the self-insured health plan side. But these rules apply to fully insured plans, and fully insured plans should be prepared to provide and comply with these requirements just as a self-insured plan.
Okay, so it sounds like the scrutiny potentially may be on the self-insured plans. However, those who are fully insured need to make sure they're holding their insurance service provider to feet to the fire, correct?
And
make sure
just more of an onus on the self-insured plan side, right? But certainly yes, and the repercussions for non-compliance would apply to a fully insured plan sponsor just as a self-insured plan sponsor.
Okay, I'm going to try to get off to all four. Let's see, Ray, for dependents who turned, you may want to take notes here, Ann Tyler. For dependents who turned 26 during 2020, which was part of a COBRA period, I've been told that they're eligible for a brand new individual COBRA period beginning January 2021 and lasting 3 years. Are those COBRA premiums also recoverable from April 1, 2021 to September 30th, 2021?
That is a great question. I would take that one offline. Need to do a little bit of review and research on that. It's a great question. And the FAQs provided for by the IRS and the DOL in April and may provide some gloss to that. They're fairly extensive, Ray, so you may want to check those out. The IRS released the FAQs, I think, on May 18th. The Department of Labor released their FAQs, I believe, on April 7th. And so they provide some additional gloss to these COBRA subsidy rules. You may find the answer there. If not, happy to have a discussion in more detail about that. That's a very explicit, specific question, and want to make sure we've reviewed the rules, could give you appropriate guidance.
In the same vein, this next question, Ann Tyler, may be more of an employment law focused question. So if this is more appropriate for Jennifer, Christine, we will certainly make sure that she sees your question. So Ann Tyler, just let me know. The question many employers have asked me is whether they can pick and choose from which extended FFICRA benefits they can offer. For instance, many want to offer paid time off if people get sick after getting vaccinated, but they do not want to offer an additional 80 hours for other reasons. Can they do this since the whole thing is optional, or is it all or nothing?
That's a great question. I am going to ask that Jennifer, as the employment law expert, focus on that question. I think it's a great one, and I'm sure she would have some good gloss and response to that. But I would focus more on that's what we have considered generally a little bit more employment focused.
So Christine, as we punt to Jennifer, Christine, we'll make sure that we give her this question in advance of her recording so that she can address this as part of her presentation. And we'll do that just for you, Christine. So thank you for that question. Thank you, Ray. Thank you, Michelle. Thank you, guys. This has just been such a well-attended. We've still got almost 100 folks online, so we just really appreciate your patience with us. And Ann Tyler, maybe it was providential that not for Jennifer, but for you, that she got strep because you had time to actually go through your full presentation and get into a little bit of nitty-gritty that otherwise would have just been impossible. So, Ann Tyler, thank you. And thank you, Lexology. I'm going to hand things back over to Jordan, and we look forward to seeing you the next time we host a webinar with Lexology, which will be very soon. So keep your eyes peeled.